Hello and good afternoon, everyone. Thank you for joining us today for our CARE community briefing, Protection Orders to Prevent Gun Violence. My name is Sarah Farouk, and I'm a Community Outreach Manager for the Inland Empire and Border Region within the Office of Community Awareness, Response, and Engagement, also known as CARE. And I will be one of your co-hosts for today.
Hi, everyone. My name is Kat New, and I'm the director for the Office of CARE, and I will be your other co-host today. Today's presentation will focus on the report, Pathways to Safety, California's 9 Court Protection Orders to Prevent Gun Violence, released by DOJ's Office of Gun Violence Prevention. This report provides an in-depth look at California's uniquely broad array of 9 court protection order processes that can prevent gun violence by restricting a violent, abusive, or dangerous individual's access to firearms. There is often a lack of awareness about all of the options available and the different safety measures each type of protection order can provide to survivors of violence and abuse in different circumstances. Our goal with this presentation is to bridge that information gap by providing this report as a critical resource and toolkit for our stakeholder organizations, leaders, and agencies who support survivors and victims of violence.
Today, we will be starting with an overview of the various protection orders and share case studies on some of them. Then we will go into a discussion of California DOJ's role in current relevant legislation. Lastly, we will close the presentation with additional resources to best utilize the protection orders. After the presentation, we will have time for Q&A. Throughout the presentation, please share your questions in the Q&A box on your screen so that we can collect them and answer them after the presentation. If you have a question for a specific presenter, please specify that in your question. If you are joining today as a reporter or affiliated with the press, please direct your questions to agpressoffice@doj.ca.gov. Lastly, for closed captioning, please click on the closed captions button at the bottom ribbon on your screen. Now, I would like to pass it to Ari Freilich, Director of the Office of Gun Violence Prevention, to get us started on this presentation.
Hello, good afternoon. So my name is Ari Freilich. My background is working with survivors of violence and abuse and on policy and legislation to create gun violence prevention programs and support implementation of gun violence prevention efforts here in California. I've had the privilege of serving as the director of the Department of Justice's new Office of Gun Violence Prevention for the last year and a half, and I'm really grateful for your time and interest today in this important topic, and understanding how we can better utilize, implement, and understand all the tools in California's safety toolkit, including the 9 court protection order processes we have available to address risk of gun violence and armed abuse. The Office of Gun Violence Prevention is an information resource hub, liaison, partner, working to implement gun violence prevention policies and programs. And in partnership with my colleagues, partners at the DOJ Office of CARE, we're here to help. We're here to help close information gaps, close the distance between government agencies and the communities served, and also to help ensure that laws and policies enacted by our state aren't just good ideas on paper, that they're effectively, equitably, consistently understood, utilized, and enforced so that they save lives, increase safety, live up to their fullest safety potential in the real world. So with those goals in mind, we've released 4 data and policy reports over the past year or so, including a comprehensive report on data concerning the impact of gun violence in California, including long-term progress, pandemic-era challenges, and current dynamics. A report on the intersection of domestic violence and gun violence. A report last week on California's fight and progress against the skip the background check ghost gun industry. And here in a nice bright orange yellow, the focus of today's webinar and briefing on California's 9 court protection orders to prevent gun violence. So this report and briefing are intended to help increase awareness and understanding about these processes, how they work, how they differ from one another, and how you can effectively utilize them to increase safety for survivors of violence in the community. As we'll discuss, all 9 court protection order processes available in California empower people to present evidence to a judge showing that they need court-ordered safety protections for themselves and or for others who may be in danger. If a court finds sufficient evidence it may issue a protection order through any of these 9 processes requested. And those processes include a set of legally mandatory safety rules and requirements designed to reduce risk, protect those in harm's way, and temporarily restrict individuals' access to firearms, their ability to keep, access, or acquire firearms and other weapons if the court finds they engaged in violent, abusive, or dangerous conduct. All 50 states have a process like this available to at least some survivors of domestic violence. California, though, has led the nation in enacting stronger protections for survivors of domestic violence and by providing a broader set of 9 protection order processes to protect survivors who are in danger from any other person. As we'll discuss, some of these processes empower other individuals to act on behalf of survivors and seek protection orders on their behalf. Before we jump into the nuts and bolts of protection order processes, I want to talk about why we're here today too. So for just a moment, this graph shows overall firearm death rates in California in orange, and the average for the rest of the United States, the 49 states in DC, on average in blue. As you can see, we're rowing in a really different direction. We've transformed public safety in this state over the last generation from a state with one of the highest rates of gun death in the country to one of the lowest. We set an all-time record low for per capita gun deaths in 2019, just before the pandemic, and we're getting back to that pre-pandemic record low in latest years. This is an especially dramatic transformation when we look at firearm homicide rates for youth under 25. 30 years ago, we had the 3rd highest gun homicide rate overall and for this youth age group out of all 50 states. Last year, we had about 50%, about half the rate recorded for the rest of the country. Protection orders, implementation of protection orders have played a critical role in this progress. And that's especially true when we look at populations that are disproportionately impacted by family and intimate partner violence, which I'm going to refer to as domestic violence. So a majority of female homicide victims in this country are killed by either a family member or a current or former intimate partner, like a spouse, dating partner. California's court protection orders, domestic violence prevention laws, and gun violence protection laws likely helped avert some of the enormous increases we saw in female firearm homicide victims across the rest of the United States during the pandemic. And we saw the same for child homicides for children under 15. A majority of this population nationally of homicide victims in this young age group are killed by a family member, typically a parent. It's important to keep this in mind. School shootings often dominate public conversation, but many youth are at greatest danger, not in their schools, but in their homes. And so California's protection order laws, domestic violence, and other protection order laws likely helped avert the near doubling in child firearm homicide rates in this age group that we saw in the rest of the country. We have more work to do to improve implementation of these processes, but they save a lot of lives. And that's why we're here today. That's why I'm grateful for your time. These are processes that help change the trajectory of a survivor's life and their communities. They can send a strong signal that legal authorities will not tolerate further violence or abuse and that victim survivors are not on their own. I want to emphasize that these are not the only processes. They are tools in the toolkit, as my friend and colleague Julia Weber will say. You have multiple safety tools available to you. You have more options, but you also have more challenges and responsibilities. You have to navigate systems, understand all the tools available to you. And so that's why we're here today to help you understand how protection orders, how all of this array of protection orders fit into the spectrum of tools in your toolkit alongside family, community-based social service interventions, voluntary or involuntary mental health system interventions, including 5150 processes in California that can include firearm restrictions as well as mental health services, alongside criminal justice system responses to when individuals are engaged in criminal conduct, including criminal threats, criminal acts of assault and violence, sexual assault, human trafficking, etc. But the focus of today's briefing will be on the protection order pathways to safety. So at the start, let's just start talking a little bit about terminology. So protection order and restraining order. California law uses these terms interchangeably for processes through which people can request that a court orders someone who is engaged in violent, abusive, or dangerous conduct to comply with a set of safety rules and requirements designed to reduce risk and prevent further harm without incarcerating that individual. The petitioner is the term for the person who starts that court case, who typically submits standard court forms requesting that the court issue the protection or restraining order. The respondent responds to that petition. They're the person that protection is being sought from, the protection order case is filed against. The protected person, if a court issues a protection order, they are in most cases, we'll discuss some exceptions, but in most cases, issuing that protection order to protect specific people who are named in the protection order. And the restrained person is a respondent that the court has issued a protection order against. So for example, a court may issue a protection order ordering a restrained person not to contact or be within 100 yards of a protected person. And then some terminology on the duration of these orders. So there are emergency orders we'll discuss in more detail in a little bit, but these are in emergency situations. Law enforcement only, can obtain emergency protection orders, typically by calling a designated on-call judge over the phone while at the scene of a violent or abusive incident or shortly thereafter, and obtaining very short-term protections driven by the emergency crisis situation. These typically expire within 7 calendar days for most emergency orders and within 21 days for emergency gun violence restraining orders. Another more imminent type order is the temporary order. So these are for cases including law enforcement petitioners as well as non-law enforcement petitioners, depending on the type of order. They can obtain short-term protection orders based on sworn statements showing the need for urgent protections prior to a full court hearing. Courts are generally required to act on these very quickly by the next business day after receiving a request for a temporary order. And they typically last up to 21 days or until the court has had a chance to schedule a full court hearing on the matter, whichever occurs first. Final orders are longer term orders issued after a court has provided the respondent with notice, opportunity to appear at a hearing. These typically last for up to 5 years, depending on the type of order. It may be a shorter or longer duration at the judge's discretion, but both parties can petition the court before and after that point to modify, terminate, or extend and renew the order. So here are the 9 court protection orders we'll be describing today. The gun violence restraining order is relatively unique. We'll discuss some of its unique strengths and limitations. We'll discuss then the 3 civil protection order processes that are typically available for petitioners who are survivors requesting protection for themselves and their family or household members. And we'll talk about the workplace and post-secondary school violence orders available to employers and school officials to protect their employees or students on campus. The emergency protective orders available to law enforcement in immediate urgent situations, and the juvenile and criminal court orders available through the juvenile courts and courts here in criminal cases. Something that's really important to emphasize here, and I'll be discussing throughout, the gun violence restraining order is the only one of these processes that uses the words gun violence in it, in the formal name of the order. All 9 of these orders include similar firearm and weapon restrictions. Essentially, all 8 other processes that do not use the word gun violence in it contain a gun violence restraining order and offer additional safety protections for specific protected people named in the court's order. All of these are gun violence prevention orders that can be used to prevent gun violence and armed abuse. So we're evaluating whether a protection order may be appropriate and which may be most protective for your circumstances. Some of the starting point questions to ask are, who is eligible to petition for this protection order? Depending on the type of harm that has been experienced and the relationship, if any, that the petitioner has with the respondent. So every petitioner may be eligible for some types of protection orders, not eligible to request others. They differ in who the order can protect. They differ in the types of safety rules and protections available through that protection order. And they also differ at the margin, at least, in how long the protection order can last. So I'm going to be running through this relatively quickly as an overview today, but there's also some much more detail in our report, as well as a quick reference spreadsheet guide in that report, meant to be a handout, a quick reference to help compare and see the differences and commonalities between these processes. Let's make sure we also understand some of their key commonalities. Presumptively, across all 9 processes, courts must include firearm and weapon restrictions when they're issuing a protection order against an individual found to have engaged in violent, abusive, or dangerous conduct. Protection orders are accessible. They're generally free to file a petition and free to request law enforcement serve the order if the case involves violent, abusive, or dangerous conduct. Across all 9 of these processes, once issued, a protection order requires the restrained party to relinquish any firearms, ammunition, or body armor in their possession or subject to their control within 24 hours, either to a law enforcement agency or a licensed gun dealer. And those either the law enforcement agency or the licensed gun dealer will sign a standard court form or receipt that the restrained party must provide to the court within 48 hours of receiving notice of the order to verify that they are no longer in possession of firearms and that they are not in violation of the court order and the law. And the restrained party across all of these processes would, in these cases, be blocked from passing background checks if they attempt to acquire firearms or other weapons. So the gun violence restraining order, as I described, is really, it's one of the more unique ones. It's also one of the newest processes here. So this was created by legislation that went into effect at the beginning of 2016. California was the first state to pass a comprehensive, what's called an extreme risk protection order process here in California called the gun violence restraining order. So I'm going to talk about what makes it unique, including, let's start with some of its unique limitations. It's important to emphasize that the gun violence restraining order, as important and essential as it is by far the narrowest protection order available in California. That's for two main reasons. It is, aside from one rare exception I'll discuss later, the only protection order process available in California that does not name a protected party. And it is the only one of these orders that does not include any other safety provisions apart from its firearm and weapon provisions. This is a process for eligible petitioners to present evidence to a court specifically and exclusively requesting that the court order someone to be prohibited from keeping, access, or acquiring firearms and other weapons for at least a temporary period. So for example, because it does not name a protected party or include any other safety protections, someone subject to a gun violence restraining order is not ordered, but through this process, to not contact someone. They're not ordered to stay away from someone. They are not ordered to attend counseling, move out of a shared residence. There are no orders governing child custody or visitation in cases involving child abuse and domestic violence. There's no process for paying costs caused by their violence and abuse. All of those processes may be available through some of the other processes that are designed to protect specific identifiable victims who have suffered violence, abuse, and other threats. But these unique limitations are actually really important strengths in some cases that make the GVRO a really important gap filler and option for cases that especially involve risk of self-harm only, or risk of significant but generalized danger to others, especially danger to groups of people or the public at large, instead of to specific identifiable victims. So for example, an FBI study on active shooters found that a majority of active shooters leaked intent to commit violence prior to their attack to at least one other person. But that in many cases, what they had communicated, what they had leaked, was not a specific threat to shoot a specific other person, but a more general goal of doing harm to others. Frequently, law enforcement, family members, community members may come across evidence that someone, through journal entries, online postings, that someone is intent on committing harm to groups of people. They're intent on committing a school shooting, a mass shooting, or of harming themselves, but there may not otherwise be a specific identifiable victim equipped to go into a court and request protection for themselves. In these cases, the gun violence restraining order in other states called the Extreme Risk Protection Order, or ERPO, plays a really particularly important option for intervention. So we see this especially for cases involving mass shooting prevention, generalized threats of hate-motivated violence to groups of people, like threats to harm people of a particular race or religion, threats to a location. Again, cases involving danger of self-harm only, where a person in suicidal crisis may not be a risk of danger to anyone else, but the gun violence restraining order could limit their access to the most lethal common form of suicide in the United States. And there's also going to be cases where there are targeted survivors who may not feel safe or able to pursue other protection orders or interventions themselves, and or where law enforcement may work with survivors to obtain a gun violence restraining order as a somewhat temporary stopgap to create space and time for other interventions, including other protection orders or other mental health system or criminal justice system responses. So the gun violence restraining order, for all 9 orders, we're going to talk about who can petition, who the order protects, what the safety provisions are, how long it lasts, and how common they are among all protection orders that include firearm restrictions in our state. So for who can petition, law enforcement are 98% of the petitioners for gun violence restraining orders in the state of California to date. But these orders are also available in addition to law enforcement to the respondents' close family members, their spouse or intimate partner, their employer, as well as certain other people who are eligible to petition if they can establish that they've had substantial and regular interactions with the respondent for at least 1 year. And that list includes a broader list, includes recent roommates or household members, teachers or employees at a school the respondent has attended, more distant family members, coworkers, and people who've had a child with the respondent. Again, these orders do not name a protected party. They only include firearm and weapon restrictions. They last up to 21 days for emergency or temporary orders and between 1 to 5 years for final orders at the judge's discretion. And these are about 1%, just under 1% of all protection orders issued in California with firearm provisions. 99% of protection orders that restrict someone's access to firearms in the state of California are orders that do not have the words gun violence restraining order in the name. But we are seeing really significant increases year by year in utilization of this process, and importantly, increases in the number of final GVROs that last for multiple years instead of expiring after days or weeks. This and a lot more data is contained in the report. And this graph again shows the percentage of all protection orders issued with firearm provisions in California last year by type of order. The red is the sliver of gun violence restraining orders. They get a lot of attention in the press, importantly, and are a really important process. But something I want to emphasize is that they are about 1% of the protection orders that prohibit firearm access and acquisition. And so let's talk about the others that made up the other 99% too. Domestic violence restraining orders are the most common type obtained through our civil courts. These are available to survivors of violence, threats, and other abusive and harmful conduct who need protections from a current or former intimate partner, including a spouse or former dating partner, a close family member, or a household member. And these are issued to protect that petitioner survivor and their family or household members. These include the same firearm and weapon provisions available through the gun violence restraining order, as well as the broadest range of other safety protections available through any other protection order process, including stay-away orders, orders governing child custody, visitation, costs caused by violence and abuse, governing mandatory counseling, requiring respondents to stay away from, not contact, not abuse or harass the survivor, the protected person, and if they do any of those conducts, they may face legal criminal consequences. These last up to 21 days for temporary orders or up to 5 years for final orders. And they're about 1/3 of all protection orders issued in California with firearm provisions. Next type of order is the elder or dependent adult abuse restraining order. So this process is available to survivors who are either at least 65 years old or who are adults that have certain mental or physical limitations and who need protections from someone who has harmed or abused them. These orders are also available to certain other people who are eligible to petition on behalf of the abused elder or dependent adult, such as conservators, guardians, county protective service agencies. And these orders are issued to protect those survivors of elder or dependent adult abuse, or sometimes the petitioner, sometimes not, as well as their survivor's family, household members, and or their conservator if applicable. Again, these include the same firearm and weapon provisions as the gun violence restraining order, as well as a broad range of other safety protections that may include mandatory counseling, orders to move out of shared residence, and again, stay away orders and personal conduct orders that designed to protect the survivor. These last up to 21 days for temporary orders and up to 5 years for final orders. And they're about 2.6% of the protection orders issued in California with firearm provisions last year. Civil harassment restraining orders are a really critical process because they are available to the widest category of petitioners. They provide some narrower set of safety protections compared to the domestic violence restraining order, compared to the elder and dependent adult abuse restraining order, but they still include some key protections like stay-away orders, personal conduct orders prohibiting any contact or prohibiting abusive and harassing conduct and contact. And they're available to someone who needs protection from any other person, regardless of the relationship, if any, they have had with the person who has threatened, stalked, or abused them. This might include a current or former coworker, a classmate, a neighbor, a roommate, a customer, some more distant family members who would not otherwise be eligible for the domestic violence restraining order based on their distant family relationship, and also for someone who needs protection from someone who's an acquaintance or stranger. These are issued to protect the petitioner survivor and their family or household members, include the same firearm and weapon provisions as the gun violence restraining order, as well as other safety protections. They last for up to 21 days for temporary orders, up to 5 years for final orders, and are about 12% of protection orders issued in our state with firearm provisions. Workplace violence restraining orders are available to protect employees who are in danger of workplace violence, threats, and abuse. So these are available to employers seeking protections for one or more employees from someone who's been violent or made threats of violence connected to the workplace, Starting in January of next year, collective bargaining representatives will also be eligible to file these petitions, asking for the courts for protection for employees they represent. These orders can be issued to protect employees of the petitioner, defined relatively broadly, who have experienced violence, threats of violence, as well as other employees and those employees' family or household members, including employees at other locations, other workplace locations owned by the employer. Again, include the same firearm and weapon provisions as the gun violence restraining order, as well as many other safety protections. They can be issued as temporary orders for up to 21 days or as final orders for up to 3 years. Post-secondary school violence orders are a relatively rare but important process available to school administrative or safety officials at post-secondary, meaning after high school, institutions of higher education, when they're seeking protections for adult students from someone who's been violent or made threats of violence connected to the school campus or facilities. Under existing law, these are available only to private school institutions, but a bill signed by the governor last month will expand this to public institutions as well, effective January 2026. These orders are issued to protect adult students at that educational institution if they've experienced credible threats of violence. They're also available to protect similarly situated students and these students' family or household members. They include the same gun violence restraining order, firearm and weapon provisions, many other safety protections, including provisions to prohibit the respondent from entering the school campus or facilities. Those are available for up to 21 days for temporary orders and up to 3 years for final orders. Already touched a bit on the emergency protective order process. Those come in 2 main types. And again, these are available only to law enforcement seeking immediate short-term protections in emergency cases, typically by calling a designated judge on the phone while the officer is at the scene of a violent incident or shortly thereafter. They must show that there's an immediate and present danger, that an emergency order is necessary to prevent harm. So there are 2 types. The first, much more common type, is an emergency protective order to protect named survivors. These are issued to protect survivors who are in immediate and present danger of domestic violence, elder or dependent adult abuse, child abuse or abduction, or threatening conduct defined as stalking. Again, these include the same firearm and weapon provisions as the gun violence restraining order, as well as many other safety protections. What really distinguishes these is that they expire very quickly. So up to 5 court days, business days, or 7 calendar days, whichever occurs first. They constitute the relatively commonly utilized 17% of protection orders issued in California last year, but because they expire so quickly, there are a relatively small number of orders actively in effect at a given time. The other type of emergency protective order, rather, is the gun violence restraining order type. So these are gun violence restraining orders that are issued on an emergency basis, obtained by law enforcement, typically at the scene of an abusive or violent incident. Like other gun violence restraining orders, there is no protected party, and they only include firearm and weapon provisions. These last for up to 21 days and automatically request a hearing to extend it into a final gun violence restraining order. And our final 2 are the protective order processes available through our juvenile courts and through our criminal courts. So juvenile court orders, these are restraining protective orders that can be issued by juvenile courts for people who are seeking protections either for or from a young person who is under the jurisdiction of a juvenile court in a range of cases. They may be under the jurisdiction of the court in a juvenile dependency proceeding involving allegations of child abuse, neglect, or juvenile justice cases involving allegations of criminal conduct by a juvenile. So these can be issued to protect someone who needs protection for or from that juvenile. They include firearm and weapon provisions, many other safety protections like other orders, last for up to 21 days for the temporary orders and up to 3 years for the final orders. And then the criminal court protective order process. So these orders may be issued by a court that's hearing a criminal case, either at the request of a prosecuting attorney, at the request of a victim or witness to a crime, and in some cases by the court acting on its own motion without anyone asking for the court to take action. So if the court believes that the victim or witness has been subject to or is likely to be subject to harm, intimidation, or dissuasion from testifying. These are issued to protect victims or witnesses to a crime and their family members, often in cases involving domestic violence that's been charged as a crime. In rare cases, courts can issue a type of criminal protective order that includes firearm and weapon provisions only, but they typically include a broader range of many other safety protections too. They sometimes last just for the duration of a criminal trial, but sometimes criminal courts issue them for the duration of probation, and in some cases for up to 10 years post-conviction, especially in domestic violence cases. And these are about 1/3 of all protection orders issued in California with firearm provisions. So my last slide here, just to wrap up what is some of these common policy and implementation principles underlying some of California's recent focus in this area and some recent legislation you'll hear about that is really trying to strengthen these processes. Is the belief in California from policymakers, from legislators working on these issues that survivors who need protection from any person should have a protection order process available to protect them from further harm. Other individuals should in some cases be empowered to seek protection orders on survivors' behalf, and in some cases, courts should do so on their own motion. The narrower gun violence restraining order process should be available to disarm people, prevent gun violence and firearm acquisition by people who are a significant danger to themselves or significant but generalized danger to groups of people or the public at large. Presumptively, courts must include firearm restrictions when they're issuing a protection order against an individual who is engaged in violent, abusive, or dangerous conduct. Protection orders must be effectively implemented in practice, not just issued on a piece of paper, but effectively served, implemented, and enforced so that firearms are effectively recovered quickly, safely, effectively from people who become subject to protection orders. And finally, respondents must be effectively blocked, not just disarmed, but blocked from going out, passing background checks, and acquiring other firearms and deadly weapons. So it gives me a great pleasure next to transition and welcome in Julia Weber to this conversation. So she's someone who's played a very big role in shaping and implementing protection order laws and processes for decades in our state. I think it's hyperbole to say that she's the foremost expert on this topic here in California. She's one of the lead consultants and authors on excellent reports and toolkits on this topic developed by the California Partnership to End Domestic Violence. She's an attorney, social worker, mediator, professor of domestic violence law, and a legal and policy expert who's worked for decades on these issues through the Judicial Council of California and Giffords Law Center to Prevent Gun Violence, among other government agencies and nonprofits. Julia, please take it away.
Well, thank you so much, Ari. Thank you for all of that critical information. And thank you to everyone who's able to join us today. I appreciate the work you do. I know we have many people joining us who work directly with survivors, victims, communities, trying to prevent, intervene, to stop violence. We're doing this during Domestic Violence Awareness Month, and this marks the 30th anniversary of the Federal Violence Against Women Act, which created, in addition to the state laws that we have in this area, we have an overlay of federal laws, which would be a whole other webinar in and of itself. And many of those federal laws went into place with respect to restraining orders and domestic violence prevention 30 years ago this year. It's also the 30th anniversary of my starting in this work. I began my career working directly with families going through child custody litigation. I was in the courts as a mediator, attempting to help them develop parenting plans that were protective and supportive of their children's developmental needs, prevent conflict, sometimes supervising visitation between parents who couldn't meet with children without supervision. And I also worked on the domestic violence docket in support of judicial officers hearing domestic violence cases. And that meant working a lot, often with self-represented litigants. I went on to represent children in family law cases. This is a drawing that the very talented Julie Giesecke, graphic recorder, did during a presentation I was giving to a group of judicial branch employees and judges in California who work on family law matters. Of course, these are civil cases. People who don't work on these matters often imagine that the way we handle domestic violence is largely in the criminal context. We know that, of course, most domestic violence isn't reported to the court system or to law enforcement. When it is, it more often ends up in a civil case or a family law matter. And that means that all of us who work with families, who work with individuals in crisis, end up having a significant role to play. We shouldn't just imagine that we can rely on addressing violence through the criminal legal system. And I like to emphasize that in all of my presentations, and really 2 points. One is that we all have a significant interest in this area and a role to play. When we wonder why someone isn't doing their part, we can often, I think, reflect more on what it is we can do to try and provide some support, some protection, some accountability, because I know we also have folks on the call, and I've certainly worked with people who have engaged in harm and threatened others. And so whatever we can do to manage and dissuade people from engaging in that kind of violent behavior is also important. And then the second part of this is that not only are we very powerful in what we can do, but we come with our own stories and our background. And I think making sure we're taking a trauma-informed approach to this work is critical. To be thinking about how our own biases, expectations, stories, beliefs play a role in our work, and holding ourselves accountable in doing that work. So the talk, of course, was much longer. These are just a few excerpts from that. But to me, this is not only important, but I think brings me hope in the work that I do. I learned a tremendous amount from all of those families, the children I represented, and this many years later, they continue to shape the way I approach policy and the problems that I try to solve along with fabulous colleagues. And California is an excellent place to do this work because we have so many good policies and so many people invested in making a difference. So part of my role in today's discussion is to make sure that you all leave with certain practical resources that you can utilize in your work so that you can be in that position of making a difference. One of those resources, I'm here today in my role as a consultant with Giffords. Giffords is the national organization founded by former Congresswoman and gun violence survivor herself, Gabby Giffords. And it merged with an organization that had started in San Francisco in the mid-90s after the horrific mass shooting at 101 California, a law firm. And a group of family members and lawyers with an interest in changing policy in California and nationally to prevent that kind of mass shooting from happening again formed what is now known as the Giffords Law Center. Back then, it wasn't associated with Giffords. The organizations merged, and the attorneys and other colleagues in the organization work in the state and nationally on these issues. One aspect of that work includes implementation. So we believe strongly that advocating for gun laws that prevent violence is important, critical, and not enough. We need to be ensuring that these laws are implemented fairly and effectively. And I'll be talking a bit more about how we do that in the restraining order context in support of the important report that's been shared today that the Attorney General issued. We have a toolkit for that purpose. The link, I believe, is available to you in the chat. It's up here on the slide. And that toolkit focuses on how do you make sure the right people are at the table so that you can identify challenges and opportunities and various other approaches to implementation. So that's a core part of what we do at Giffords, and that we work closely with the Attorney General's office where possible, and others, including a lot of community-based organizations, to make sure that these laws designed to save lives actually do. Another important resource I want to highlight is endinggv.org. This was a resource developed with the support of Cal OES, the Office of Emergency Services funding, the California Partnership to End Domestic Violence, the state's Domestic Violence Service Provider Coalition developed this document, and it's a combination of looking at where domestic violence restraining orders, DVROs, and other related orders that include protected parties may be most effective and useful, and looking at when gun violence restraining orders may be effective and useful, and really helping to distinguish between those different approaches. So that's available through this link. One of the other aspects that is important in distinguishing at this point GVROs from DVROs is around enforcement. And that is that domestic violence restraining orders in California have associated with them under SB 320 a set of relinquishment requirements. Not only are people who become prohibited expected to get good information locally about how to comply with the prohibition, But when there is non-compliance as the result of a review of the file, or because the court held a compliance review hearing, that non-compliance is required to be reported to law enforcement and the prosecuting agency. The court, the civil court, is required to report that non-compliance. Thankfully, we've seen a huge uptick in compliance in domestic violence restraining order firearm prohibition cases when people get good information about how to comply. And the governor just signed SB 899 into law. It'll take about a year for implementation, but that new law will ensure that those firearm relinquishment procedures, those requirements, are applied across the board to the various other restraining or protective orders that we've talked about today. So relinquishment, implementation of those prohibitions, the really important news there is that when we implement them, we see a reduction in domestic violence homicides. So we know that we can continue to work to prevent gun violence and save lives by ensuring that relinquishment happens consistently, no matter what door folks walk through in all the various firearm prohibiting orders we have in the state. So how do you go about doing this and assisting folks? I want to draw your attention to courts.ca.gov. That's the judicial branch's website. That's where you're going to find the most up-to-date forms. You're also going to see rules of court, opportunities to comment on proposals to change court forms. There's a wealth of information here. And if you go to forms and rules, that's where you can pull down a particular form and search for what you might need if you are petitioning or responding to or assisting someone who might be responding to or petitioning for a particular order. So you'll take a look at that through courts.ca.gov, and you'll be getting a handout with this information as well. If you're looking for more guided assistance, you don't know what form to look at, how do I start the process, or how do I respond, or which restraining order makes the most sense in this particular case. And I want to emphasize here that we're looking at efficiency. It's not a good idea to be thinking about, let me see if I need 3 or more restraining orders. The idea is that these generally include in one order after hearing, I should say, because in most of the cases, domestic violence restraining orders will start with an emergency protective order or form EPO 001. Then the petitioner or person who needs protection might avail themselves of a temporary restraining order by asking the court to issue one of those. And then that could lead to an order after hearing. So it's one case type, the DVRO, with 3 different orders. But when I talk with folks who say, well, shouldn't you get, for example, a GVRO and a DVRO? Generally, in almost all cases, that would be more problematic than useful, in part because you create inefficiencies. One might be denied, the other one might be granted. You might have different judicial officers. The firearm prohibiting remedies, as Ari pointed out so well, are available in the domestic violence restraining order context, as well as a whole bunch of other remedies. Similarly, in civil harassment orders, a whole bunch of remedies that protect people and provide for firearm and ammunition prohibitions. So this is a part of the court's website, the Self-Help Center area of the website, where you would go to abuse and harassment on that first page I just showed you, and then you can be walked through the different options for petitioning or responding to restraining orders. And then I'm going to spend the next few minutes just walking you through some of the various specific aspects of these orders. So domestic violence restraining orders, again, Ari went over the details of what those provide, why they can be helpful in various cases. To make it more concrete, some case examples. Cal Matters a couple of years ago covered the case of Callie Garay, or Callie Trout. Married name had been Callie Garay. And tragically, Callie was shot and killed in front of her 3 young children as she was going to a medical appointment. She had a domestic violence restraining order against her estranged husband, her abusive husband. She had included in her petition information about him having access to firearms. And unfortunately, there's evidence that the court did not carefully review that part of the petition. The order was issued, and while he was prohibited and restrained from contacting her, there was no effort made to ensure that he complied with the firearms relinquishment or prohibition requirement, and he maintained access to firearms. Her homicide led to significant changes in the law. We have Cali's law, which requires confidentiality around certain details to prevent abusive restrained parties from being able to get the kind of information he was able to get that led to her murder. I highlight the case here because it also contributed to the policy discussion around SB 320 and the firearms relinquishment effort. We need those prohibitions that Cali should have been able to avail herself of, and we also need to ensure that relinquishment happens. So there's enormous amount of training that happens in this space, as well as efforts around relinquishment. This is what an order can look like. Again, unfortunately, this is an example of a case in which the restraining order was issued, but the custody and visitation provisions that could have allowed for no contact with the children or limited, safe, secure contact were not put in place. And because the parties were allowed to stipulate to having supervised visitation at an unsecured location without a professional monitor, there was no metal detector, and Dad, in this case, brought a firearm to the location, shot and killed his 3 daughters, turned the firearm on himself, died by suicide, and also killed the supervised visitation monitor in Sacramento. Again, I use this as an example because we have to be thinking about how we can ensure that not only are these orders issued, but that we follow up with safety planning, that we include them as part of a broader safety plan. So if someone's living in a confidential location, if child custody and visitation are an issue, simply prohibiting access to firearms may not be adequate. This led to a change called SB 599, which it has the court needing to consider whether in-person visitation makes any sense, whether virtual visitation would be another option if folks can't afford or find access to a secure supervised visitation site, or whether no contact would make more sense if there's non-compliance. And also some changes to the child custody provision so that family courts have to take more seriously non-compliance with firearm prohibitions. So none of these orders generally stand alone. They have to be thought of in conjunction with other efforts to ensure safety and to prevent violence. This is all happening at the same time that the U.S. Supreme Court this year issued its opinion in U.S. versus Rahimi. That was a Texas case where Mr. Rahimi agreed to the equivalent of a domestic violence restraining order in Texas, and no follow-up with respect to his currently owned firearms, so no relinquishment procedure was in place, and Mr. Rahimi maintained access to those firearms, and over the course of several months, shot up the town of Arlington, Texas, engaged in a series of violent acts. He appealed, he was convicted on a number of different counts. One of them was being someone who was prohibited from having a firearm due to the restraining order and maintained ownership of that firearm. While he was incarcerated, he wrote a letter explaining why he had a firearm. And I highlight this again because we have to understand people may argue that they have access to firearms or they need access to firearms for a variety of reasons. In this case, Mr. Rahimi said it was to protect his family. And so what we know is that he had agreed to a restraining order because he had engaged in harm against his family. And he should have been given the information about how to comply, that we need to hold compliance hearings, and we need to follow up a la SB 320. The U.S. Supreme Court overturned the lower court's decision. The lower court's decision, the Fifth Circuit had said that Mr. Rahimi had been denied his Second Amendment rights when he had been restricted from having access to firearms due to the civil domestic violence restraining order. But the U.S. Supreme Court in the 8-1 decision overturned the lower court's decision and upheld the federal prohibition, noting that the Second Amendment does not preclude Congress, legislatures from enacting provisions that prohibit access to firearms when we're talking about domestic violence, when someone is a danger to others. So that was a victory for this important set of policies. Now, the civil harassment example, that generally includes, this is the form. I should note that these forms have been developed by the judicial branch to be in plain language. They are available for review in the top 5 languages in California. So if you have a petitioner or respondent who needs information in one of those languages, that's also available at courts.ca.gov. The official documents are all in English, but you can get all that information more accessibly that way. Civil harassment, generally, we're talking about people who are not in intimate relationship. I've seen this used when there are neighbor disputes, when there's concerns about non-intimate partners stalking or harassment. It's the second most utilized civil restraining order that includes firearm and ammunition prohibitions. And you can see it's designed as a form, again, to be accessible to self-represented litigants. Each of these forms, these form sets include info sheets. So for workplace violence, for example, you're going to see WV 100 info. How do I get an order to prohibit workplace violence? These are situations sometimes after there's been a mass shooting in a workplace, I'll get phone calls from folks or emails saying, shouldn't there have been a gun violence restraining order? And I have to point out often that the sometimes not as well known, but used actually more often than gun violence restraining orders, is the workplace violence prevention order. If someone's abusing or harassing colleagues, shouldn't come on site to a workplace, the workplace violence prevention order provides those kinds of restrictions on that person's behavior, as well as the firearms and ammunition prohibitions. Check out the info sheets because they can answer a lot of questions for folks. And of course, the gun violence restraining orders, I think Ari covered well, and very important gap filler when you don't have the relationship, when focused individual abuse and harassment may not be an issue. Very important in terms of dealing with self-harm, threats of suicide, as well as generalized mass shooting threats. You'll see also that these form sets include 800 info sheets, DV 800 info, GV 800 info, and so on. They explain how folks are expected at a statewide level to reduce or prevent access to their firearms and ammunition. And there are only 2 options in California. You can sell or store your firearms. You can do that through a licensed gun dealer or with law enforcement. Some of the numbers we're seeing right now is there's a bit of a tendency to relinquish to law enforcement directly in the domestic violence restraining order context or the gun violence restraining order context, but dealers may provide another opportunity for people to store or sell their firearms as well. And then folks should be in the process of creating local forms with similar kind of information. And then they need to provide that receipt directly to the court so that the court can determine if there has in fact been compliance. And then lastly, I'll just note that we have a number of projects underway. One of them is out of San Mateo County, and that began with the involvement of the Attorney General, who spoke at a convening that happened a couple of years ago. I am a huge fan of convening key stakeholders in your community to come together and to talk about what's working, what the challenges are for your community, where the opportunities are, how to leverage the particular resources you have in your community. And we saw that happen in San Mateo County after a mass shooting that occurred actually in Santa Clara County. And San Mateo said, what can we do to prevent this kind of violence from happening, and undertook an effort to first do a landscape analysis about what was working, what the challenges were in the county, and eventually arrived at this point where they are handling those relinquishment procedures through the court process in all the various case types that we've talked about today, and following up accordingly. And they've seen a huge uptick in the number of firearms that are being relinquished just by providing information to parties and going through that compliance review process. So we know this can work, and I appreciate your time and again, your work in this area. And so now it's my pleasure to introduce Michael Redding, who serves as the Special Assistant to the Attorney General, advising Attorney General Bonta on criminal justice, law enforcement, and firearms. So thank you very much, Michael. Please go ahead.
Great. Thank you, Julia. Nice to hear your presentation as always. And thanks to everybody for joining us today and giving us this opportunity to go through these things. So exactly, as Julia said, I advise the Attorney General on a few different things, including firearms. I'm going to talk a little bit just about what the Department of Justice's role is here. I come to this work, I was a prosecutor at the state and then the federal level. And when I came over here about 3.5 years ago, that was my big question is what exactly does the California Attorney General do, and what is the role of the Department of Justice, especially in a space like this? So the way that I think about it is that, you know, the Attorney General really has two hats that in this case that he wears. One is the Chief Law Officer, so the Constitution designates him as the Chief Law Officer, which means that he is to ensure that all laws are enforced appropriately and equitably. And then he also is a constitutional officer, meaning he is in the Constitution and has some sort of inherent power because of that. Under the Chief Law Officer, what I don't have up here is that we the Department of Justice spend a lot of time defending California's firearm law. So anytime one of those laws is challenged, we're in charge of trying to get it upheld by a court. But two other areas that are more relevant to our work today. One is that the Bureau of Firearms is under the auspices of the Division of Law Enforcement. So basically that's the law enforcement wing, and then we have a specialized firearm section. The firearm section includes and runs what's called the Armed and Prohibited Persons System, which you may have heard before. But basically, you know, in a nutshell, what it does is takes the list of people who are prohibited, cross-references it with the list of people who have registered firearms, and comes up with who is armed and prohibited in the state of California. So we got a question in the chat about how relinquishment is tracked and enforced. There's different ways that it's tracked and enforced at the local level, which we'll talk about a little bit more. But at the back end, if a firearm isn't relinquished after somebody becomes prohibited, it goes into the app system, and we have agents who go out and try and retrieve those firearms. And then another way is through the Office of Gun Violence Prevention, which Ari is the director of, and so much of what he is doing, which I admire their work so much, is really looking at firearm violence in a broader perspective and addressing how we reduce it, meaning that traditionally people who run prosecutors' offices are focused on prosecuting crime as it comes in the door. That is one effective way of reducing crime, certainly. And Ari is really at the helm of looking at all these other different strategies. So, and then under the constitutional officer, you know, kind of two broad ways that we can address this work, or that the AG can address this work. One is by sponsoring and supporting legislation, saying, hey, here's something we're missing. This is a tool that we can have. And the other is sort of using what you would call the bully pulpit, meaning using his sort of power and the fact that people will listen to him to talk about these issues and talk about, in this case, firearms and firearm relinquishment. So really what we've been focused on, there have been so many great laws that have been passed in California over the last 20 or 30 years that have had such a dramatic effect on firearm violence, and specifically in this realm of protective orders. We've really been trying to push and really push with our partners in this space relinquishment, because we very firmly believe that obviously the safest time to retrieve a firearm from an individual is at or immediately after the time that they are prohibited, meaning the shorter amount of time that a prohibited person has access to a firearm, the better. And really, as much as I admire the work that the APS agents are doing, going out and retrieving firearms, on a certain level, that's too late. We've let the firearm stay with that person, and that's sort of a cleanup job when we should really be trying to focus more on relinquishing the firearm at the time that the person becomes prohibited. So there have been a number of laws. Julia already mentioned SB 320 that have gone into effect over the last few years, which focus on this. To step back just for a moment, Julia also mentioned the Rahimi case, and that's known for a variety of reasons, not least of which it was obviously a United States Supreme Court case. But it's really a powerful example of somebody who, it's hard to say slipped through the cracks, but somebody who retained their firearm despite restraining orders, despite a lot of indications that that person had a firearm, meaning they were displaying it, firing it, and is a very classic example of somebody who should have been disarmed, and who was very dangerous because they weren't disarmed. So again, some of these laws that we've been pushing and have been fortunate enough to see pass over the last few years have really focused on relinquishment. So SB 320, which Julia was a pioneer of, once a person determines that a restrained person still has a firearm and has not relinquished it, then the court is to report that to law enforcement and to the prosecutor, and law enforcement is to take all necessary action to retrieve the firearm. So it really formalizes the idea that law enforcement has to do something about firearms that aren't relinquished rather. AB 818 passed in 2023, came into effect at the beginning of this year, and that created free and mandatory law enforcement service of DVROs and GVROs, and also mandated that for DVROs and juvenile violence restraining orders, and mandated that when serving these orders, law enforcement must take into temporary custody any firearms that they see that are in plain sight or pursuant to a lawful search, meaning if an officer serves a restraining order and sees a firearm there, or goes and has a search warrant to seize a firearm, or to get into the house to serve the search warrant, or serve the restraining order and execute a search warrant, then those firearms have to be retrieved. And then SB 899 extended that relinquishment and service, so extended a number of those things to basically the remaining gamut of protective orders. So now, starting in 2026, there will be free and mandatory law enforcement service when requested of those orders, required relinquishment of firearms found in plain sight pursuant to a search, and the court is to notify prosecutors and law enforcement agencies when firearms are not relinquished. Finally, just a few more bills that have been passed over the last couple of years. This is just an abbreviated version, but basically a few other cleanups to make sure prohibited persons cannot have body armor, as that's been used in dangerous situations. And then, for example, AB 2917, which will go into effect next year, clarifies the risk factors courts are to consider when issuing a GVRO. So all that is to say, quite a substantial amount of legislation that have really, has really gone in and really been focused on this idea of making sure that, the piece of paper that we give to people is more than just a piece of paper, that it's enforced, and that firearms are taken from people to ensure everybody's safety. With that, I'm going to turn it back over to Ari for just a little bit more, and then we are going to start fielding questions with Ari, myself, and Julia.
Well, so we just wanted to share about these two future funding opportunities, in particular, grant funding opportunities for especially public agencies to engage in work to help support public education and awareness and increased implementation and more consistent and effective implementation of protection orders. So one is what's called the Burn SCIP, State Crisis Intervention Program grant. That funding stream was created by by the federal government, which passed the Bipartisan Safer Communities Act, and created this grant program that flows through California's Board for State and Community Corrections, or BSCC. They allocated their first round of funding through this program earlier this year. That was open to every city or county government agency in the state. And I would say we would have wanted to see more applications for that program. So that program will likely be re-released for the next 4 years. Please look out for that. We don't have a specific date. They haven't reopened the grant yet, but that funding will continue to come from the federal government to support increased awareness, utilization, implementation of the range of protection orders available to prevent gun violence. And the second is the Firearm Relinquishment Grant Program that's administered by California's Judicial Council and will be permanently funded in the future through a future partnership with DOJ. So that is funding for courts as the lead agency, superior courts in each county, partnering with one or more law enforcement agencies or prosecutors' offices in their jurisdiction, really focused on having more dedicated staff time and personnel whose job it is to ensure protection orders are effectively, equitably, and consistently implemented and available. So more folks whose job it is to ensure protection orders meaningfully protect, and that people who fail to relinquish firearms are promptly identified and safely separated from their weapons. And then I'd also just point to some of the local opportunities. Julia mentioned the San Mateo County. They weren't waiting for state and federal grants. They asked their county board of supervisors to jumpstart that work, got $1 million investment from the county to fund that, what I believe is becoming a best practices model for ensuring implementation of the full array of protection orders to prevent gun violence. And we've also seen some at the state level, so at the congressional level, some programs specifically ask for directed spending, appropriation projects directly allocated to their programs through the budget, through the appropriation process to fund court protection order training, public education, and implementation programs. So encourage you to find out if your community if there are gaps in your community that could be supported through some of these funding streams. And I think we're going to turn it back to Michael for some Q&A.
Great, exactly. So now some of these questions came in before, some have come in during the course of this. So I'm going to start firing off questions to Julia and Ari, and might answer one or two myself. So Julia, I'll turn this one over to you. You touched on this briefly, but how should GVROs operate in situations of domestic violence? Are there special considerations that should be taken into account?
Well, thank you for the question. And I would say that GVROs should largely play no role in domestic violence cases generally. So it should be that they show up very rarely. The whole idea behind domestic violence restraining orders is that they are survivor-centered, survivor-led. There's an initial 7 days where law enforcement has requested an emergency protective order in a DV situation to provide a little bit of time for that victim survivor to work with an advocate to develop a safety plan to make sure that an order is the safest way to go. We know that in some instances, restraining orders can result in additional violence instead of being protective. And because of that, we need to be talking with survivors about confidential housing, relocation, other kinds of protections. And the restraining order process sometimes involves contact. You got to go to court, you got to show up. And again, in GVROs, you don't have all of those remedies that Ari went through. And as a result, the GVRO, again, 98% are pursued by law enforcement, a very important tool. But because that protection isn't there, we need to be looking at the DVRO if we're concerned about firearms and there's intimate partner or family violence or abuse or stalking, child abuse, child abduction threats, and so forth. So there are absolutely special considerations. The only time that I can really envision GVROs being helpful might be if a victim survivor says, I'm not ready to go to court yet, and I need some time to think this through. I understand that I won't be protected, and I'd like law enforcement or someone else to help me with getting firearms and ammunition out of the situation. But it is so important that that be done in a very, very careful way with full understanding that it doesn't restrict the person from coming into a shared residence, from contacting the person who's experienced abuse, and that a court in the future might look at that and say, well, why are you asking for child custody? Now, if it was domestic violence, you would have gotten a domestic violence restraining order, and custody and visitation might have been handled in that process. So there are other ramifications, especially around custody and visitation, because that can be handled in a domestic violence situation, and you can protect children through a DVRO as well. So one of my concerns is that we see a lot of coverage of gun violence restraining orders as the newest way to prevent access to firearms and ammunition. In some states, those extreme risk protection orders fill a gap where they don't have the same kind of state laws that we have in California. I would point out that in all 50 states, most civil domestic violence orders are covered by the federal law that was upheld by the Supreme Court, 18 U.S.C. 922 G8. So not all states have extreme risk protection order laws. We have the GVRO in California, and it's a really important tool, generally not one that's that effective in domestic violence cases.
And I would just add, so Ari phrased it that all other orders include a gun violence restraining order. I thought that was a good way to frame it that I hadn't heard before. So that's great. Julia, I'm going to stay with you just for 1 second. We got one question that came in and you mentioned it, so I'm going to come back to you. The question was about emergency protective orders and the possibility that that kind of an order or another order could trigger violence. You mentioned in your remarks some ways that people could address that by one, making sure that the protective order is one that protects their person, to having a plan for where to go and what to do, sort of a plan once the order issues. Anything else that you suggest sort of across the board for any of these orders?
Well, I'd say the most important thing is certainly if law enforcement is called to the scene and they're involved, there are a bunch of requirements to go with that, removing firearms in plain sight, taking firearms out of the situation in the moment, with or without an order, because they have other kinds of powers and ability to restrict access to firearms when there are concerns along those lines. So I would say make sure that you have protocols and procedures in place to reduce risk in the moment. And ultimately, especially because it's Domestic Violence Awareness Month, take domestic violence seriously. That is that, you know, we sometimes think of it as a private conflict and one that will be resolved if we simply separate the parties. But what happens when law enforcement or other folks who are intervening are no longer in the picture? That person and the broader community may still be at risk. So be very thoughtful about those other options. Like I said, confidential housing, relocation, making sure they get connected to services. Confidential counseling is available for people who are victim survivors of domestic violence. Make sure someone who is engaging in this kind of behavior gets access to batterers intervention programs and other programs that are designed to reduce risk and prevent future harm, because most survivors, all they want is for the abuse to stop. And I would say that while arrest and prosecution isn't always necessary or the best way to proceed, it's still an available option. There are crimes associated with this behavior. Folks are always asking about red flags. Domestic violence is a huge red flag. 2/3 of mass shootings have some kind of connection to domestic violence. So let's take it seriously. Let's give people a chance to do the right thing and change behavior. And let's really increase our focus on public safety as fairly and effectively as possible.
Great. Great, thank you. Ari, I'm going to turn this over to you and sort of merge two questions, one that we got before and one that we got during. So the question from before is, how is the AG working with community-based organizations and youth in communities to address gun violence? And then the question that we got during this was about the status of AB 28. Those two are connected. So I'd ask you to talk a little bit about, the work that you've done with CBOs and then sort of where AB 28 fits into all of that.
Sure. Yeah. So thanks for the question. I think the short answer is that this is a department that's really committed to more partnership with community-based organizations and recognizing that addressing gun violence requires both defending our laws, enforcing our laws, and investing in prevention and protection. And that takes many forms. Some examples are that DOJ has created the Office of CARE, specifically dedicated to community outreach and partnership and engagement with community-based organizations. A lot of expertise and partnership focused on violence prevention, and organized a series of roundtables as a collaboration between the Office of CARE and the Office of Gun Violence Prevention this year, convening hundreds of community-based organizations, hundreds of attendees work with community-based organizations, community-led violence intervention initiatives up and down the state, especially those that receive funding through the CalVIP grant program to identify, one, to uplift their success, and their critical contributions they make to public safety, and also to hear about the challenges they face, some of the administrative barriers that government might be able to do a better job of addressing. Question was about AB 28. So that's legislation, actually was originally modeled on a bill that was introduced by then Assemblymember Rob Bonta about a decade ago. Ultimately passed as AB 28, places a modest firearm industry excise tax on retailers in firearms and ammunition to create a permanent gun violence prevention and school safety fund in our state. That law took effect in July of this year. It has been subject to some lawsuits, but so DOJ is defending those lawsuits. Those are ongoing, but the funding stream that will come out of that new law will make really important permanent investments in community-based violence intervention programs, including $75 million per year to permanently sustain the CalVIP, California Violence Intervention and Prevention Grant Program, that funds community-based approaches to interrupting cycles of violence among individuals at highest risk. It creates a $50 million per year investment in new school-linked, school-based safety and behavioral health services for youth in communities disproportionately impacted by violence, a range of other investments in victim services, increasing support for solving more shootings and homicides, and the court-based firearm relinquishment program focused on ensuring protection orders effectively protect. So could go on at length. I think another important focus for this department has been on ghost guns, an industry that was selling skip the background check access to deadly weapons to youth and to minors, and was responsible for a majority of the increase we saw in crime guns during the pandemic, especially in youth violence. So it could go on at length, but I think those are some examples of how DOJ is working to partner with CBOs and recognize their importance in preventing gun violence.
Great. And Ari, that actually touches on another question that we got, which is, what is DOJ doing to reduce ghost guns? You released a report, I guess, was it last week or 2 weeks ago, which you mentioned at the outset. Maybe you could talk just a little bit more about what's in that report and what the department's doing.
Sure. Yeah. So this is, I think, one of the underappreciated stories of gun violence in California and the nation over the last decade is that an industry cropped up selling nearly complete gun build kits and related products designed to enable people to arm themselves without passing any kind of background check. And that was explicit in their advertising and their business model. They sold to minors, they sold to adjudicated domestic abusers, to people who could not pass a background check in our state. California was the epicenter of the crisis in many ways because we have the strongest gun safety laws in the country, and a lot of folks were working to make a profit by helping people who couldn't pass a background check skirt those laws. So what has DOJ done? California's passed some of the most comprehensive legislation anywhere in the country. I think the most comprehensive legislative response, as well as litigation and enforcement work. So litigation to hold ghost gun companies accountable in court, litigation to sue federal regulators and prompt them to take some action to address the ghost gun crisis at the federal level, but really especially to change the laws we have here in California, ensure that ghost guns are sold as the firearms they are, and to to create a lot of civil tools too. So we have the criminal enforcement, we're requiring background checks for ghost gun products, but also new tools to, for instance, hold accountable those who are selling 3D printers and CNC milling machines that are designed and programmed to produce ghost guns, civil tools to stop the distribution of the code that folks download to print firearms in some cases, a range of other tools like the Firearm Industry Responsibility Act that DOJ sponsored to regulate the ghost gun industry as well and create new tools for victims, survivors of gun violence to hold ghost gun companies and related companies accountable in court too. One thing while I'm unmuted, I meant to mention on AB 28 and CalVIP is that using that AB 28 funding, the CalVIP program is prepared to reopen the grant. So take this opportunity to plug that grant will reopen, likely release an application in November for applications due this coming March. Really important grant opportunity for community-based organizations focused on this work.
Great. Thanks, Ari. I'm going to answer a few questions and try and just quick answers, and then Julia, I'm going to ask if there's anything that you want to highlight, given that it's Domestic Violence Awareness Month. So one of the questions was about how we make sure that domestic violence abusers do not get firearms and how they are taken from them. So in terms of not getting them, exactly, all of this is to make sure, if the process works right, and we have to be mindful of it and make sure that it works correctly, then these orders are entered into the system. All these background checks happen anytime you purchase a gun in California. A background check comes to the California Department of Justice. And if everything is in the system, then that person will be denied access to purchasing legally a firearm. Obviously, I say legally there because Ari just talked about ghost guns and the possibility for that. On the front end, really, that's what we've been focused on is that relinquishment and making sure that local law enforcement are taking firearms, making sure that we're doing the work of taking firearms, we being BOF and apps of taking firearms that remain in people's hands. But it is difficult work to make sure that happens. And I have a background as a prosecutor, so I continue to like that work. I know it's difficult, and sort of as Julia talked about, we really tried to take a victim-focused approach to that. But it does also mean having law enforcement, or it may mean having law enforcement involved. You can't seize a firearm on your own from somebody. You need law enforcement to do that, and I recognize, and that's some of the work that we're trying to do here today, and just in the department as a whole, is really build trust with communities, as law enforcement, even if I'm not a sworn officer, build trust in communities so that people will feel safe to come to us and say, I believe this person has a firearm, now they have a restraining order against them, and I really am looking for your help in retrieving that firearm, because I know there are many good officers who want to do that and want to find those. And so then two other quick things. One, how do we ensure that officers comply with sort of the rules that are laid out? So all of those bills sort of have a couple of built-in protections. I wish I could tell you that there was some, grand master at the end of the line who was checking all of these to make sure that every single firearm was relinquished. That is ultimately what the apps program is doing. But really, there's a court backstop, there's a law enforcement backstop. And a lot of these things are built in now to the system to make sure that that law enforcement and courts and everybody are complying. So ultimately, what is ensuring that happens is that they, in many instances, have to go back to court to show that work has been done. And then we also received a few questions, which I really appreciate, about law enforcement's when law enforcement are perpetrators and how we handle that. And I will just say that those are some of the most delicate cases that we handle, and some of the most important cases that we handle. I know there's a long history, and again, I work very well with law enforcement and admire so much of the work that we do, but we also know that historically there was a culture of sweeping those things under the rug. We can't wave a magic wand and solve those problems in one fell swoop, but I'm very optimistic. But by doing this work day in and day out, we can start to build trust by holding those people accountable just like everybody else. So with that, I think to close this out on the Q&A, Julia, I'd love to turn it back over to you and highlight any resources that you think are worthy of highlighting in Domestic Violence Awareness Month.
Sure, thank you so much. And I think you now have in the chat the link to the hotline.org. I encourage folks to utilize that as the National Domestic Violence Hotline. That is the centralized database for resources connected to domestic violence. And it's the kind of safety planning resource that can assist with these complicated and very dangerous cases. For example, when law enforcement is the perpetrator. Because those are cases where you're going to be wanting to think about whether or not someone needs to look at confidential housing relocation and other kinds of safety provisions, those kinds of delicate, complicated cases. Again, especially, it's not just about removing the firearms because someone may have access to other kinds of means of harming the person who needs to be protected. And if I could just quickly, I know someone was asking about, can therapists be petitioners? In California, anyone within the restrictions of their confidentiality because of their professional role, and that's a whole other presentation, can ask law enforcement to be petitioners, and then a smaller group of people can be petitioners themselves. One of the reasons we haven't been supportive in the past of therapists being petitioners is because we think people being able to seek help is critical, and otherwise that person becomes the petitioner and you're looking at facing your client or patient as that therapist in a courtroom and a litigation context, which can be extraordinarily difficult in terms of building rapport and trust and confidence. So that's a whole other training about the role that mental health practitioners can play. But I want to just reinforce that it doesn't mean that firearm prohibiting remedies aren't available to therapists when they're concerned about clients who might be a danger to themselves or others. But there's a very careful consideration has been given to the idea of why we would not necessarily want therapists to be petitioners. So thank you so much.
Thank you. Thank you to Ari, Julia, and Michael for your informative presentations and your expertise today. And thank you to our attendees for the great questions that you posed. And thank you to all 100 or so of you for joining us today for our community briefing on protection orders. We hope that this presentation was informative and useful to you. Please keep in contact with us. You can always reach us by emailing care@doj.ca.gov. The PowerPoint presentations are available on our website right now. The recording of this presentation will also be available there shortly. So please join us for our next community briefing, which is Know Your Voting Rights, happening next week on Wednesday, October 16th at 11 a.m., where we will discuss new publications and actions by the DOJ related to voter protections. We are excited to be joined by the California Secretary of State's office, as well as some community-based organizations focused on voting rights. We'll also have our final Demystifying the DOJ presentation on December 11th, which will feature our Office of Care. Please join us by registering at the links provided in the chat and seen on this slide. Thank you so much for joining us today. Stay safe.